Thank you, Mr. Conyers. Thank you, Mr. Chairman. I am glad that we're here today addressing these issues of abusive lawsuits in the patent system. As has been mentioned by others, we do have a problem. It's widely agreed to among patent assertion entities, sometimes called patent trolls. These lawsuits, these abusive lawsuits that are brought, can easily cost $2 to $10 million apiece, and that's why when a meritless lawsuit is threatened, it's easy to extort a smaller payment to make it go away, and that's what we're trying to deal with here. This is a big issue for small businesses. Professor Colleen Chen of Santa Clara University Law School, now with the White House, did a study and found that more than half of these suits were against companies with less than $10 million in annual revenue. And that's why this bill, it's not a perfect bill, but why this bill has such broad support. It is genuinely a bipartisan bill. I'm a co-sponsor of this bill, along with Congresswomen Anna Eshoo, Mike Honda, Peter DeFazio, Jared Huffman, and many others. And at a time when the country is saying, can't you just work together? We have. It's, you know, reasonable people can differ, which is why we have this debate here today. We have 40 members of the House Judiciary Committee. Only 5 members voted against reporting this bill out. And that's remarkable. The White House has just issued a very strong statement of administrative policy. They support this bill. And so at a time when too often we're seen as the battling Bickersons, we have support across the aisle with the White House to do this. What does the bill do? It deals with pleading requirements. Oftentimes these patent assertion entities will allege infringing, but they don't really with any particularity say what is being infringed. It does a change in attorney's fees that matches the existing rule in copyright. I oppose fee shifting in civil litigation generally, but the Congress has on many occasions narrowcast fee shifting to deal with specific problems. This would join that. I would note that the shifts would not occur unless the party's position is unreasonably justified. So the court is not to allow this shift if the party has a reasonable case in fact or law, or my colleague Mr. Jeffries had added a severe economic harm. I would note that this is supported from startups to big companies. I would ask unanimous consent to put in the record letters from the Application Alliance,
time has expired.
Engine Alliance, and the Electronic Frontier Foundation, and I yield back.